Welcome to On Texas Football. I'm Bobby Burton. Thank you for joining us for the Saturday conversation. With me today is Mitt Winter, attorney for Kenny Hertz Perry Law in Kansas City, Missouri. He is an NIL expert, recognized expert, also covers law as it relates to NCAA, college athletes, etc. Again, recognized expert on this, the information around NIL. And I wanted to ask you and bring somebody else into this, Mitt, as opposed to just pontificating by ourselves what this thing might look like in the future. Thank you for joining us and talking with Texas football fans today.
Yeah, thanks for having me. Excited to be on.
Yeah, absolutely. So we all know this House settlement that is coming down. I believe it's April 7th in front of Judge Claudia Wilkin. Has a number of elements to it, including athlete compensation for their NIL. Exactly. Somewhere in the neighborhood of $20 million for the Power Four conferences, at least. What do you think, first of all, the likelihood of every aspect of this ruling becomes actual law and gets passed by Judge Wilkin? Let's start with there, and then maybe we can digress and talk about other aspects of it.
Yeah, if I had to place a wager on whether she's going to grant final approval to the settlement agreement or not, I would probably bet yes, just based on the fact that she's already granted preliminary approval to the settlement agreement back in September of 2024. And before she did that, she did bring up some issues that she had with the previous draft of the settlement agreement and told the parties to go, I think her exact terminology, go back to the drawing board on a few specific parts. They did that, came back to her with an amended settlement agreement. And at that point, she granted preliminary approval. But that said, there is still the possibility that she does not grant final approval to the settlement agreement. When she granted preliminary approval back in September, she had not yet seen all the athlete objections to the settlement agreement that have now come in. This past Friday, January 31st, 2025 was the deadline for athletes that are class members in the various classes of the House settlement to object to the settlement agreement or opt out of the settlement agreement. So both of those things happened. There have been a lot of objections filed to the settlement agreement by athlete class members, basically saying that the settlement is not fair for them for various reasons. And then some of the athletes that completely opted out of the settlement, at least the damages part of the settlement, some of them have either filed their own lawsuits now that are, basically the same claims as in the House versus NCAA case, or joined another lawsuit that was already pending called the Fontenot case. But on your specific question, I think it's more likely than not. I would say maybe 55-45 or 60-40, maybe.
So not a slam dunk.
No, at least in my opinion.
Yep.
I mean, it's hard to say what's going on in the judge's head when she reads all these objections. And there's still that, as you referenced, the final fairness hearing is on April 7th. And at that point, athletes can actually appear in person and speak and say why they don't like this settlement, why they don't think it's fair. The NCAA conferences and even the plaintiff's attorneys also will get to speak and say why they think the settlement is fair and should be approved. But it's hard to really know what a judge is going to do, taking all of that stuff into account. We're all just really guessing. But based on what she did in September, I would say, chances are better than not that she does grant final approval.
Is there anything that came up? You mentioned the deadline that just passed, January 31st, for extra consideration as far as this going through. Was there anything that caught your eye there that might delay or change what she rules? So in other words, anything additional beyond that September approval, anything you heard from folks that said she really needs to take this into consideration or this is fundamentally different than maybe what she approved?
Yeah, I mean, the one thing I was probably the point in the settlement agreement that received the most objections was the proposed roster limits. So there are a lot of athletes that filed objections, saying this settlement's not fair. I'm going to lose my spot as a college athlete if I am currently a college athlete, or even some high school athletes that objected and said, I'm not going to have a spot. I've already been told by the school I was committed to that I don't have a spot on the team at the school I was planning on going to. So that wasn't something that was raised previously, at least that I can remember, in September before she granted preliminary approval. And then I guess an important factor is the Department of Justice did weigh in on its view on the settlement a week or so before that January 31 deadline. Basically, it said this settlement agreement still violates antitrust law because it still includes a compensation cap on the amount of money that college athletes can be paid, and that cap wasn't agreed to by the athletes, so it still violates antitrust law. So that could maybe give Judge Wilkins some pause. Some of the other objections that were filed by athletes also raised that issue of the cap on compensation. She already addressed or heard objections related to Title IX in September, but there have been some more Title IX objections raised as well. I don't think that's going to affect her at all because she's heard that, and not only in the House case, but also she's the same judge from the O'Bannon case and the Alston case, and she kind of poo-pooed those Title IX issues back then, so I don't think they'll swear. But hearing from these athletes is, not something that she took into consideration before. So maybe that changes her mind now.
That's interesting. It's interesting you mentioned compensation because this is a sidebar almost. 20 to 22 million, I guess, is the number that people are saying that the first year would actually take in. Of that, Texas Tech, for example, has come out and said that 15 of that 20 will go towards football, right? Well, what if I told you, and everybody knows this, at least 12 to 15 college football programs are well in excess of 15 million in compensation already, or NIL.
Yeah.
Does that sway a judge? Is that about the cap on the compensation level that is already telling them this cap isn't high enough, perhaps? Or is that just totally irrelevant to the facts before her? Like, will that impact her thought process at all? Or whether or not it should be, it's fair, I guess, and paying market level?
Yeah, it could if somebody brings that up. It may have been brought up in one of the objections that was already filed. There have been so many of them, I haven't read through every single page of all of them, but maybe somebody brings that up at the hearing on April 7th. That the fact that if you're putting this cap of, let's say it's $20.5 million on the amount of NIL compensation a school can pay to all of its athletes, and you have some schools there are some schools paying more than that.
Absolutely.
Already just an NIL compensation to their football team, it's pretty easy to see how those football players are going to get less than they're currently getting after the settlement when you do have a cap on that compensation. She did say during the September hearing on preliminary approval that people don't like it when they have things taken away from them that they basically have now. And she was referring to a different part of the settlement with respect to rules on collectives, but it's basically the same principle. She was kind of saying, well, they're allowed to get this compensation from collectives now, and under what you're proposing, they wouldn't. And so you're taking something away from them. So maybe that same type of argument would work with respect to, well, some football teams are getting paid $20 million right now, and under this new model, they can only be paid, 15 or whatever that number is at a school. So it may have some appeal to her if it gets brought up.
Okay. I think that lays out, everybody knows the basic rules. Not everybody, but a lot of people know the basic rules. They're trying to limit the amount of money that goes in and pay players for their name, image, and likeness, and try to create a sense of equity or equitability, I guess is a better word, right? Among all the major conference schools, and really kind of set out and say, okay, everybody's playing under the same rules with the same salary cap, et cetera. But is this really even set up as a salary? I mean, is the NCAA allowed to even do that? Because there's no collective bargaining around a salary cap. You just have to be a member of the class. I mean, what is it really address and not address, I guess, is my problem here. Is like it's like putting a Band-Aid over a bullet hole.
No, yeah, I completely agree with you. With respect to the salary cap that you mentioned, no, it was not collectively bargained, and I think you brought that up because at the pro level, like in the NFL and NBA, they have salary caps, which are legal because they've been agreed to between the Players Association, the NFLPA, and the NFL, or the NBPA and the NBA, which makes them exempt from antitrust law. So this cap that is going to be placed on college athlete compensation as part of the House settlement will not itself be exempt from antitrust law. Athletes will just not be able to sue the NCAA and the conferences for injunctive relief related to that cap, which means they can't sue to say this rule cannot be enforced against us. Future college athletes, however, will be able to sue and say this cap has damaged me financially. Under the terms of the settlement, as long as it gets put in place the way that it's currently envisioned in the settlement agreement, future college athletes also would not be able to sue to enjoin the salary cap. But I do think there's going to be some legal action around that cap, probably by future college athletes at some point, saying, I would make more money personally if this cap did not exist. And if they're successful, it would, in my opinion, would probably have the same sort of effect as a lawsuit that says you can't enforce this rule anymore. Because if a court finds that with respect to this athlete, he's being damaged by this cap, it's probably going to apply to every other college athlete. And so at that point, probably wouldn't be able to keep enforcing that cap.
So that brings me to my second question. What are some of the issues with the settlement that this doesn't actually resolve? That's a potential one right there. Is if it doesn't really solve anything for a sophomore in high school,
right?
How are we getting to a point in college football where we all are playing by the same rules and the rules are set each and every year? If you're already saying there's a workaround for a sophomore in high school that's coming up, that's the next great wide receiver, quarterback, what have you.
Yeah, I wouldn't call it a workaround. And the way they did draft the settlement agreement, they're trying to avoid that, but legally they just can't because it's not a collective bargaining agreement. So in addition to that, the salary cap being vulnerable to antitrust attack, there are also some rules around restrictions on collectives, and they don't refer to them as collectives in the settlement agreement. They refer to them as associated entities and individuals. Under the terms of the settlement agreement, all NIL deals that these basically collectives and boosters would do with athletes going forward would have to be submitted to a new clearinghouse entity that would assess each deal to see whether it's within, quote, fair market value. And if this entity, which is going to be operated by Deloitte, looks at a deal and says, we don't think the amount of money being paid for the services being performed by the athlete are within fair market value, then they're going to tell the athlete, you can't do this deal. And so a lot of people think there's going to be litigation around that as well. Not necessarily by the athlete who's told you can't do the deal, but by the collective or the booster who wants to do a deal with an athlete who is not bound by the terms of the settlement at all. They're not a party to the settlement. They're a complete, separate third party. So they would be able to sue if this new clearinghouse entity says you can't do this deal with this athlete. And a lot of people think that will definitely happen at some point.
It just sounds like a mess.
Yeah, and then you have the roster limits, which there will probably be litigation around that if those get put in place, because there are a lot of athletes who are going to lose their spots. And then there's probably most certainly going to be some Title IX litigation as well, because as you said, most schools, at least the P4 level, are planning on paying out around at least $15 million of this $20.5 million to their football team, probably 3 or 4 to men's basketball. So that leaves, $1 million, $2 million, whatever for everybody else.
Yeah.
And some people think that violates Title IX. As I mentioned, that was, a lot of objections to the settlement were Title IX raised. And a few days before objections were due, or last week, I think, or last week or week and a half, whatever it was, the Department of Education put out what's called a fact sheet, basically saying NIL compensation needs to be paid out proportionally to your male-female student-athlete population, which could mean 50% supposed to go to males, 50% females if your student-athlete population.
And that was done when President Biden was in office in his Department of Education versus now President Trump's Department of Education, which like I said, it all and you're in the middle of it. It sounds like a hot mess, and like we can't really get our hands around it. So let me ask you this: as someone that's seen it from all of these legal ways and nuances, what do you think is the right way to go forward? Like, what should the NCAA and its member schools, as well as the athletes, what should they do? What's our way out of this hot mess?
Yeah. In my opinion, it's negotiating the rules that are going to exist with the athletes. And whether that is a model where some college athletes are employees and they have their players association for their sport, let's say like P4 football and P4 men's basketball and women's basketball, and they negotiate the rules for their sport, or if it's something short of employment where college athletes are allowed to not collectively bargain, since they wouldn't be employees, but negotiate what those rules are. And that would include potentially an antitrust exemption for those rules. In my opinion, until college athletics gets to that place, it's just going to be continuing litigation and instability, just because the athletes haven't agreed to the rules that are being placed on them, especially when you talk about a salary cap and things like that, things that are, going to be limiting and reducing their compensation. And obviously that's different than the way things are now. It would take some restructuring for sure and be a lot different than the way things are operating now. But in my opinion, that's what is necessary to actually bring real stability to college athletics.
So athletes get a seat at the table.
Exactly. So a real seat at the table. Some people say they already have one, or that they already negotiated the rules via the House settlement, which I don't necessarily agree with, because it's not like you had the football players in a room saying, "Do we agree with this salary cap?" That's not what happened. It wasn't like you have in the NFL. And some people will say, well, they have the student athlete advisory committee as part of the NCAA, and so they get their input that way. Well, that's still part of the NCAA. It's not something separate. So I agree with you. It needs to be a seat at the table, and it needs to be independent of the NCAA.
Otherwise, we're just reshuffling deck chairs on the Titanic.
Yeah, that's how I view it. Yeah,
it's like literally we act like these are big things that are going forward, and maybe they end up being. Maybe the House settlement is some sort of precursor to a next step. But, and I said workarounds, that you can punch holes in it, I guess is the way I would put it. That's a better way to say it.
Yeah, okay. It's not going to end the legal attacks on the model and in the litigation, like I think a lot of people have been hoping for.
I know, and it just leaves it. I don't understand why the NCAA and member institutions don't actually reach out and give the athletes a true seat at the table. Is there, in your mind, is there a reason for that? Is it because it might make them employees in the end, and NCAA schools don't want that to happen? Why aren't they getting a, in your opinion, proper seat at the table?
Yeah, I mean, they definitely want to avoid employment at this point in time for sure.
Why is that? Is that
yeah?
funding?
I mean, I've had this conversation with a few people recently. Based on everything I hear from people and just also reading people's viewpoints and statements, I think the big one is cost. The perceived cost, at least, they have, if they're employees. And I think when people talk about this, most people that are very adamantly opposed to college athletes being employees, in their mind, if one college athlete's an employee, then all of them at D1, D2, D3 are all going to be employees. And so when they think about that, they're like, geez, if we have to pay all of those athletes, let's just say even minimum wage, that's a lot of money. And we can't afford that. And so we're no longer going to be able to afford to have an athletics program at all. So I think a lot of people's head goes to that. And I think that's the main reason why a lot of people are opposed to it. But in my view, you don't have to have a world where if some college athletes are employees, all of them are employees. I think there's different ways to operate college athletics programs where some are employees and some are not.
Well, right now we have some that are club sports and some that are division or full sports, and then even beyond that, intramurals. And so I can see setting up football and the revenue-based sports may be employees, and if you're non-revenue, you're not.
Right. Yeah. For sure. But I think a lot of people just don't want to go there yet. They haven't gotten to that point where they're like, well, we still want to have the same model and the way we operate the soccer team to be the same as the football team, even though everyone knows they're different, obviously different beasts, different animals. But I think a lot of people feel like, well, we're taking away this great opportunity for the soccer team to compete at this high level and have all this awesome training and facilities, and we don't want to do that.
Yeah, I hear you, and I think I also agree with you that they're not the same. When you probably have 10 staff members, I'm just using Texas as an example, including the general manager, that probably makes not just the head coach, but 10 staffers that make more than the head soccer coach.
Right.
I mean, and so it's a different animal, a different beast, so to speak. Last question, and I thank you so much again, Mitt Winter. Kenny Hertz, Perry Law, there in Kansas City. Last question for you. Assuming the settlement is approved, at least in some ways, right, in this April 7th, what is the true status of NIL, and how will collectives continue to play into the equation, if at all, in your opinion? So that's a very loaded question because there may be pieces of this that get nixed, but you're in your mind, what's the thought process there, and where does the Texas One Fund, for example, end up at the end of the day?
Yeah. So as we've already talked about, if the House settlement does get approved as it currently stands, most of the NIL compensation that will be paid to athletes will be coming from schools at that point. So right now, as you know, and I'm sure a lot of your listeners know, most of the NIL compensation being paid to athletes right now is coming from collectives. So the hope with the House settlement is that it shifts who is paying that compensation and who is actually contracting with the athletes for most of the NIL compensation being paid to them from collectives to schools. As to whether collectives will still be around in this model, I think that's going to depend on the school. Some schools have already basically gotten rid of their collective. Other schools are planning on keeping their collective around. Because if every school is going to be able to pay out the same amount of NIL compensation, that $20.5 million to their athletes, in a lot of people's minds, and I think they're right, that next level of recruiting competition is going to be, all right, we know that Texas and Texas Tech and A&M are going to pay out around $15 million to their football players. But if we want to win these recruiting battles, we're going to have to basically guarantee these recruits that they're going to get more money on top of that. And so in some places, we're going to keep our collective around to pay them more than what we can pay them from the school. And so it'll be people trying to kind of test out this new clearinghouse entity. Where is that that fair market value number for this athlete and for that athlete. So I think it'll be interesting to see how people, for test that out and see how strict that's actually going to be. So at least at a lot of P4 schools, their collective will stick around to kind of serve that function of getting over the cap.
Interesting. All right. That's Mitt Winter, attorney with Kenny Hurts Perry Law. Looks like, just to sum up, athletes need a seat at the table, most likely, to really get to the crux of this issue. It feels like the House settlement may be at some level just kicking the can down the street further, but there will be some meat to it, at least, and some parameters, most likely. But still, it is clear what you're saying, but at the end of the day, we've got some roads ahead of us to make college sports back to where it's stable. I think it's never been in a better situation financially. Everybody's watching. It's not hurting the game on the field of play, but behind the scenes, it's got to get stable so that we can grow it beyond. All right. Thank you very much, Mr. Winter. We appreciate you very much having a good day. And that's going to be the Saturday conversation here at On Texas Football.